Good morning, everyone. My name's Craig Lawrence. I think let's just give it another 30 seconds to let some late arrivals to come in. We'll start in a moment. Okay, good. It's after 9 o'clock now, and we do have a full program. So I think it's better that we start. As I said a moment ago, my name is Craig Lawrence. I'm a director with the HR and the IR consultancy. I'm joined by a number of colleagues I'll introduce in a moment. Just to explain, I think all of you would have obviously seen the advert that went up for the webinar. We felt it was appropriate, given that there is significant confusion in the workplace regarding the issue of cannabis or marijuana or dacha. And in the next 2 hours, you will hear those different terms used. If we could just treat them interchangeably. The confusion has been caused by the fact that I think all of us now know that the use of cannabis from a private point of view largely is legal in South Africa. And there have been a number of judgments that have influenced how employers respond to their employees using cannabis. And we felt that, especially given the Enova matter, which you'll hear a lot about in a moment, that has added to the confusion and the issue of zero tolerance. Most of us have been working in the human resources, industrial relations, and health and safety space, have relied on zero tolerance as a way of drawing a line. And our policies were largely based on zero tolerance, i.e., somebody under the influence of cannabis was just unacceptable in the workplace. And the Enova case, amongst other cases, has now challenged that. That is not the situation anymore. And employers are well advised to think about how they handle the issue of employees who are intoxicated with cannabis or test positive for cannabis, how they handle those employees. So the world has changed. To use a sailing analogy, the waters are unclear and they're choppy. And even today, as we're talking, you'll hear that there aren't crystal clear answers to all the questions, but we will endeavor to help employers to understand the best way to navigate through these choppy waters. I am joined by a number of colleagues, as I said earlier. The first speaker is Tanya Mulligan. She is a partner at Cowan-Harper-Madikizela, very well experienced in labor litigation generally, but has a particular interest in the area of substance abuse and cannabis. Likewise, I'm very pleased that I'm joined by an old colleague, Tibor Szana, who is the retired Chief Inspector from the Department of Employment and Labor. So a deep and genuine expert in the health and safety field, who will bring a very practical perspective, but taking cognizance of the regulatory environment at the same time. And then I'm joined by a new colleague, Doug Armstrong, to my left, who has 40-odd years of both human resources and general business leadership experience. And he is going to look at this through a lens, a practical lens for an organization. Given what Tanya has said and what Tibor has said, how an organization should respond. And that's the essence of the program. It's the 3 speakers. We only have 2 hours. If I can suggest that we leave the questions and answers for the end, there should be enough time. I'll try and summarize at the end, and I will do our best to handle all the questions and answers for the questions that come, and we'll do our best to handle them before we answer. Just a commercial break for those of you who don't know. Human Resources and Industrial Relations Consultancy is a small human resources consultancy. Our competitive advantage, we believe, is that we're a small group of highly experienced consultants. We have no junior consultants. It's a small number of human resources and industrial relations practitioners that have either been in the corporate world like myself or in the consulting world for many, many years. And we offer a range of general human resources services, including assisting with disciplinary investigations, disciplinary inquiries, employment equity matters, and anything in the broad human resources and industrial relations space. We have a working association with Cowan-Harper-Madikizela, which is where Tanya comes from, who are one of the leading employment law firms in South Africa. And we're very proud of that association. So when we provide a service, we have Cowan-Harper-Madikizela at our back when and if we need them. With no further ado then, Tanya, I think I'm going to hand over to you. Tanya's subject is on the issue, understandably, on the legal context and case law. So she's going to give us the legal background before we move into the more practical safety and then the organizational matters with Doug. Thanks, Tanya.
Thanks, Craig. Good morning, everyone. So let me start. As we know, this whole cannabis story kind of started with the Minister of Justice and Constitutional Development versus Prince. So that was one of the first and the biggest cases dealing with cannabis. Now, I'm not going to go into too much details or too much facts. I think you guys are all familiar with it, but he had a law degree. He was a Rastafarian, and he was refused to be admitted as an attorney. And the reason for this was because he had 2 previous convictions for the use of cannabis. Now, his main argument was that he required to use cannabis as part of his religion. This took a good couple of years for the Constitutional Court to make a ruling, but ultimately the Constitutional Court found, let me just move this, that certain provisions of the Drug and Drug Trafficking Act, as well as the Medicine and Related Substance Control Act, are unconstitutional in that they infringe the right to privacy. As a result of this judgment, persons, including employees, are now permitted to use or possess cannabis in private for use for personal consumption. Now, I think the reason you guys are all here today is what is the implications of this and what has happened since. But as the use of cannabis is now permissible, employers have seen an increase in the use by employees. This has led to an increase in dismissals, and I think some misunderstanding on the position in the workplace. So if you have an employee and this employee tests positive, these are the most critical questions we need to ask. Firstly, is the employee intoxicated or under the influence at the workplace? And what does this mean? What does the term intoxication mean? What does it mean to be under the influence in the workplace? Secondly, is there a contravention of the zero tolerance policy? Thirdly, when can an employer implement such a policy? And ultimately, is an employer entitled to dismiss? Now, when charging an employee, it's quite important that a distinction is drawn between charging an employee for being intoxicated while at work and charging an employee for breaching a policy and a procedure at work such as, for example, your zero tolerance policy or your substance abuse policy. And the reason you need to make this distinction is because different tests apply, and that will ultimately lead or assist you when you need to litigate on this front. Now, I'm going to start by just taking you through some in the case law dealing with intoxication. What is the test? So if you charge someone for being intoxicated at work, and then we're going to look at the tests for breach of policy. So for intoxication, one of the seminal cases, and you'll see as we go through the rest of the cases dealing with cannabis and then ultimately the Barlow decision, they all kind of refer to tanker services. Now in tanker services, this is a very old case, but the employee was driving a 32-ton lorry. He was asked to take a breathalyzer at an offloading point, but he refused. Now, this case was quite clear. He smelled of alcohol, he slurred his speech, and he was ultimately charged for being under the influence of alcohol. In this case, the court held as follows when they had to look at what does it mean to be under the influence. The court found the difficulty with providing the charge brought against the respondent is that intoxication is a matter of degree. The respondent would only be under the influence of alcohol if he was no longer able to perform the tasks entrusted to him, and particularly the driving of a heavy vehicle with the skills expected of a sober person. This is quite a bizarre way or a bizarre judgment in that they found that you are seen to be intoxicated only if you are unable to do the job that you were hired to do, which is quite strange because, you know, some people might function better than others. This sentiment was then duplicated or echoed in the following case of Trent Tire. Now, although Trent Tire's case, which is also a LAC case, dealt primarily with whether dismissal is an appropriate sanction, it very much echoed the same principle to say, the commissioner accepted that the employee was under the influence of alcohol, but correctly found that there was no evidence that the intoxication was of such a nature as to render him incapable to perform his duties. There was no evidence that the employee had consumed alcohol before he reported for work on the day of the incident, or that the reason of the consumption of intoxicating liquor, he was unable to perform the task entrusted to him. Now, this is also one of those seminal cases, but I think it also highlights the defenses we encounter, and I'm sure you guys encounter it every day, to say, look, it was my latest one that we heard was, I took Listerine at home before I came to work, and that is the reason that my alcohol limit exceeded the threshold. Or it was some sort of a medicine. So it's very difficult to determine whether they actually consumed alcohol and when they consumed it. Now, with cannabis, this is even more difficult to determine, and we'll definitely go to the tests and, you know, how long cannabis stays in your system and all of that, but it's very difficult to determine when someone actually used cannabis. Now, if you look at the second one, your second option is breach of policy. You can have a substance abuse policy, or you can have a zero tolerance policy. But in all instances, it must be operationally appropriate to have such a policy in place. Now, if we look at a zero tolerance policy, one of the good cases is Air Products South Africa versus Petit. And in summary, in this case, they were manufacturing and distributing oxygen, hydrogen, and carbon monoxide. The employee tested positive at the gate via breathalyzer. And like I mentioned, he argued that he had consumed the alcohol at home the previous day and it was just still in his system. The Labour Court said that his dismissal was justified. But when looking at the zero tolerance policy, the court found, and it's very important, the zero tolerance policy will only be accepted only where circumstances necessitate the adoption by the employer. Thus, when pursuing a zero tolerance policy, the employer has a duty to show that the dismissal is appropriate and proportionate to the offence. Now, as we go through the cases dealing with cannabis and ultimately the Bar Award decision, I think please keep this in mind, because ultimately, if you need to implement a zero tolerance policy, you must make sure that it is appropriate and proportional to do so in the circumstances of your company. There's no one size fits all approach to adopt. You need to evaluate your business and determine whether you can implement a zero tolerance policy or not. All right, now we're going to look at some case law on cannabis. Now that we have the background of what is intoxication, there's a breach of a policy, what are the requirements for zero tolerance, I'm going to take you, and it's going to go quite quick. I just want to look at the legal principles of some of the cases of cannabis that our courts have decided on, well, last year and early this year. The first one we're going to look at is SGB. Now, in this case, the employee was seen smoking dacha at work. So you actually smoked it at work. You think it's quite a clear case. He tested positive via a saliva test. He had a clean record and he showed remorse. He was ultimately dismissed. And I think the question here for the court was, is this a dismissible offense? So if an employee has been at the company for many years, he shows remorse, he's got a clean record, can you still dismiss? What is the appropriate sanction for something like this? In this case, the Labour Appeal Court held, irrespective of mitigating factors, such misconduct attracted dismissal in line with the employer's zero tolerance policy. The decision of the appellant to dismiss the employee was fair, taking into account the nature of its business and similar sanctions which have been imposed on other offending employees. So again, do you have a zero tolerance policy? What is the nature of your business? Is it justifiable? Because in those circumstances, it could very well justify a dismissal of an employee. Now, in the next case, I've added this in because it's quite humorous. Now, this employee got very smart. And his main argument was that, look, since the Prince judgment, dacha is no longer a drug. This has been legalized. Because it's no longer a drug, I'm not covered by your substance abuse policy or your zero tolerance policy. So you can't measure me in terms of that. Ultimately, the court made quite a strong ruling in this case to say that the Prince judgment does not overrule the provisions of the Occupational Health and Safety Act. That is so important. So even though it's legalized, we always have the Occupational Health and Safety Act, and it does not overrule it. It is also evident from the Constitutional Court judgment that it does not offer any protection to employees against disciplinary action should they act in contravention of the company's policies or disciplinary codes. So employees can most certainly not utilize the Prince judgment in order to get out of policies or to say it's no longer a drug, it's legalized. There are still consequences, and the provisions of the Occupational Health and Safety Act still apply. Now, Marasi is definitely one of the big cases. And when I go through this, and when we ultimately go through the Bar Award decision, I need you guys to try and compare the two, how they argue it, what they focused on, to see the difference in how the court dealt with it and the ultimate outcomes of the cases. Because for me, this is fundamental. But let me go back to the facts of the case. So in this case, the employee advised his employer to say, look, I want to go on a traditional healer training program. It's going to be 18 months. The employee was based at an oil refinery, and this oil refinery had really strict health and safety rules. Now, to accommodate the employee, they actually took quite a lot of steps. They said, it's fine, you can go on your training, you can even relocate to Petro SA and Mosselbaai in order for you to be closer to your traditional healer school. Now, What's very important about this employer is that they did not have a zero tolerance policy in place. Instead, they had specific limits of cannabis, or specific limits for cannabis and alcohol at the workplace. So that means you get tested. If you are below the limit, you can go through. If you are over the limit, it means in terms of their policy that you are intoxicated. And then you don't have access. Now, in this case, as part of his traditional healing program, it required him to use cannabis. When he tested to enter the site, he tested above it. It was marginal, but he was above the limit. The employer said to him, look, you are unfit for duty. What we will do is you are required to go home. You can go on annual leave or paid sick leave. You're, like I said, you're not fit. So it wasn't a dismissal. They merely said to him, go home. When you come back, we'll test you again. If you're under the limit, you can enter the site. But for as long as you exceed this limit, you need to stay home and utilize annual leave or paid leave. And if that runs out, you'll obviously have unpaid leave. Now, he eventually did go back to work. He tested below the limit, but he also referred a case to the Labour Court. And his main contention was that preventing him from accessing the site amounted to unfair suspension for discriminatory reasons. He said it was discrimination of the company to require an employee to use annual leave or sick leave entitlements while at home. And he says, my limits were not that high. I was not intoxicated. We again look at this word. What does it mean to be intoxicated? I might be above a limit, but I'm not intoxicated. He said there was no health and safety risk. Now, the employers, when they responded to him, they were very smart. And this is something we would definitely recommend, is when you are encountered with a situation like this, it's always good to bring the focus back to your Occupational Health and Safety Act. And in this case, the employer responded to him to say, the substance detected through the lab test is above the allowable threshold for fit for duty purposes. The standard and applicable legislative regime is primarily for the protection of both your safety and that of the employees, and consequently, the outcome of the test necessitates Petro SA to refuse entry on its premises until your next confirmatory test is negative. So they took quite a reasonable approach to say, look, this is for health and safety reasons. This is why we've implemented it. If you are above the limits, go home. Use unpaid leave, sick leave, annual leave, test again and come back. But you must remember that this is based on our health and safety requirements. Now, critically, and please also keep this in mind, what evidence was led by the employer's witnesses? They spent a lot of time looking at the fact that they followed a European Workplace Drug Testing Society guidelines in relation to the levels that they set. So these are the cutoff levels in relation to cannabis and alcohol before they considered it to be safe to enter the site. So they went through the research that they had conducted, and they explained why the certain levels were actually implemented. They also laid a lot of evidence on the fact that the refinery was a major hazard in terms of the Occupational Health and Safety Act. They also laid a lot of evidence on why they needed testing and confirmatory testing. So a lot of focus in this case was placed on occupational health and safety. And they also laid evidence on all the steps they've taken, all the correspondence, how they've tried to accommodate the employee. This is so critical, and it's such a good outcome in this case because the court found that it is not unfair discrimination where discrimination takes place based on the inherent requirements of the job. Let's unpack that for a second. So the court found that there is no direct discrimination, because that was one of the contentions, to say, look, we are not directly discriminating against anyone. This policy applies to all employees. It doesn't just apply to Mr. Morasi. Everyone who needs to enter the site needs to go through the same protocols, the same tests, and the same consequences flow from it. It could arguably be indirect discrimination because it could have a disproportionate impact on members of employees' religion and cultural groups. For example, if you go back to the Prince case, the Rastafarian, or for traditional healers, it could have an indirect discrimination effect because if you need to use cannabis for religious purposes, yes, it could be. However, the inherent requirement of the job is an absolute defense. You will always go back to what is your occupational health and safety? Why have you implemented it? Is it proportionate? Is it reasonable? There were significant health and safety risks on site. They've used internationally accepted standards applicable to levels of cannabis. And the company, in addition to that, also had additional obligations in terms of South African law, given the nature or the dangerous nature of the site. So in conclusion, the court found, and this is quite a good quote from the judgment, and said, once it is accepted, as I do, that testing negative in terms of the policy is an inherent requirement of the job of all Petra SA employees, given the nature of their work environment and the requirements of health and safety legislation, an unfair discrimination claim, whether alleged to be direct or indirect, must fail. So critically, again, it all went back to the nature of the business and the requirements or steps that implemented to ensure health and safety. The court further found, in any event, the court is of the view that the evidence as a whole established that Mr. Morasi was not suspended, so it wasn't an unfair suspension as he alleged. He did not face disciplinary action. He applied for sick and annual leave for the period he was unable to enter the workplace. He was permitted to do so by his line manager, who from his conduct and testimony treated him with sensitivity and respect. I don't actually know how many other employers would be this accommodating towards the employees, because they did ultimately take a lot of steps to try and accommodate Mr. Morasi for his religious reasons. So ultimately, the court found that no unfair discrimination has taken place. Now, the key takeaways for me from the Morasi judgment is that they were able to indicate very strongly, and they laid sufficient evidence on the occupational health and safety risks, the reasons for their policies, what levels, and the steps they have taken in order to assist the employees. So if you compare this to the Barlow decision, you'll see, or the facts that they led there, you can see that a lot more emphasis was placed in this case on the occupational health and safety and the analysis that they had conducted. Okay, now to get to the case why you guys all joined today, I'm sure, is the Eneva and Barlow decision. Now, this decision also took many years to come to a conclusion, but let me take you through the facts quickly. The company had a zero tolerance policy. Now, again, very much like Morasi, if an employee tested positive, they were sent home for 7 days and said, go home, come back, we'll test you again before you are allowed to access the site. During this time, you can use your annual leave. So it's very, very similar, but they also took disciplinary action against these employees. Now, in this case, the employee tested positive during a routine test. So they did, I think, I stand to be corrected, but I think they did either annually or biannually, they did normal health and safety or medical tests on all employees. And on this occasion, the employee failed. They sent her home. She came back, she tested again. So she tested positive on 4 occasions. Now, to tell you a bit more about her, she's 50 years old or around that region. She was an analyst, so a desk job employee. And she quite openly admitted that, yes, I use cannabis outside of working hours. in terms of the Prince judgment. I'm entitled to use it at home. She said she uses it mainly to assist her for insomnia and severe anxiety that she experienced. So she linked it to, firstly, a medical condition, to say, look, I've gone off prescription drugs. I'm now using cannabis. It helps me sleep. It helps me with my anxiety. But yes, I do also use it for recreational purposes. And another allegation or averment that she made is, she said, it's also for spiritual reasons because it makes me feel closer to God. So she's kind of developed a reasoning, but initially her reasoning was for medical purposes. Now, it's important, and I think that's why this whole case is so controversial, because at the time of testing, she showed no signs of impairment or suspected impairment. So she didn't slur speech, didn't look intoxicated. And again, what does that mean? So I'm going to test positive, whether I'm above a prescribed limit or zero tolerance limit, but there's no indication of her being high or being stoned, whatever you would like to call it. When they questioned her about all of this, she only informed them of her decision. So it's also another thing to take into account of the fact that she didn't, out of her own accord, tell the employer, look, I'm using this, being aware of the policies of the company for medical reasons. Only after she tested positive did she disclose this. Now, when she was put through a disciplinary inquiry, the chairperson recommended a final written warning, but this was ultimately overturned by the company due to the fact that she said, I'm not going to stop using cannabis. I'm going to continue using it because I have a right to use it in terms of the Prince judgment. So a final written warning would never have helped the situation. So ultimately it led to her dismissal. The employee then referred both an unfair discrimination and automatically unfair discrimination claim to the Labour Court subsequent to her dismissal. Now, the Labour Court took quite a firm approach to the matter and said that, look, despite the decriminalisation of the use of cannabis, you are entitled to discipline your employees, and that employees receive no protection from the Prince judgment. So you can see this kind of confirms some of the previous case law that dealt with the matter, to say, look, the Prince judgment doesn't give you any protection. You are entitled to discipline your employees. All right. The court also referred to the case of Tankos, which we looked at first, to say, look, the question is not whether she could perform her function. So it's not whether she was intoxicated or not. But this is the second leg, and that's why I initially explained it's quite important for you to make a distinction between, are we charging employees for being intoxicated, or are we charging them for breaching a policy? So the question was whether the zero tolerance policy was justified. Did she breach the policy? The Labour Court found that there was no discrimination, that the policy, like Marasi, applied to all employees, that there was no medical evidence to support her claim, that she needed this for medical reasons. So there was generally a lack of evidence laid on her medical condition. And regardless of her medical condition, ultimately, she quite openly admitted, yes, I also use it for recreational purposes. So it's not just medical, it's not just spiritual. I do use it recreationally. And the court found that the policy served a legitimate safety purpose and that it was rationally applied. The Labour Court made quite a strange finding, and I put it in here because I don't 100% agree with it, but the Labour Court found that unlike alcohol, one cannot determine a level of impairment based on the test results. Proof of impairment is therefore not required as with alcohol. It is automatically assumed that one is under the influence of cannabis due to its intoxicating nature. And I think the Labour courts got a bit or conflated the issue of intoxication here with breach of policy, or tried to mix them. because it's quite important that you separate them at all times. And if you look at impairment, what does it mean? When will someone be impaired, as opposed to, is there policy? And in terms of this policy, have they acted in breach of it? But regardless of that, let's look at what happened in the Labour Appeal Court, because this is really the most recent and binding law on the matter. Now, in the Labour Appeal Court, the court used Parkson versus Lane, and that is the test we use in relation to discrimination, because she said, look, I've been unfairly discriminated against, and we'll go through the grounds that she raised. But the test for this is, the first step is to establish whether there's a policy that differentiates between people. The second step entails establishing whether this differentiation amounts to discrimination. The third step involves determining whether the discrimination is unfair. And if the discrimination is based on any of the listed grounds in Section 9, and those are obviously race, sex, gender, sexual orientation, religion, it is presumed to be unfair. Now let's look at the arguments. Now, in this case, the LAC rejected the arguments raised by the employee. Like I said, she initially argued that it is discrimination based on religion or my spirituality, in that she felt that she was closer to God when she used it. Now, we can't uphold that argument due to the fact that regardless of that, you don't have to analyze that, because she admitted to using it recreationally. The distinction between alcohol and cannabis, so the employee argued that you're treating people who use alcohol different to those who use cannabis. And the company quite successfully argued to say, no, it's the same testing regime, same policy applies, we treat the employees the same. So there was no differentiation here. And her last argument, really, she said that, okay, but the company allows alcohol. It's zero tolerance, but it allows alcohol once a year at the year-end functions. And the court found that that might be the case, but it's quite a rational differentiation as to why they allow it once a year. All right, so if we now look at the direct grounds of discrimination, is there arbitrary discrimination? In order for you to prove an arbitrary ground of discrimination, you must show that there was an impairment to her human dignity in a comparable manner to discrimination based on a listed ground. In this case, the employee submitted that the discrimination infringed on her dignity by violating her right to privacy, as we've seen in the previous cases, because it subjected her to a humiliating process that portrayed her as a junkie. And I think her main argument here was to say, look, I've gone through all these tests and retests, like I am a drug addict or a junkie. I'm entitled to use it in my house. I'm entitled, in terms of the Prince judgment, to use it. And this has caused me great humiliation. Now, the finding of the Labour Court. The court found that the appellant worked in an office, and this is quite important, and that her job did not entail operating dangerous machinery. She was also not required to drive for the respondent or perform any duty where impairment from cannabis would present a risk to her or others in the workplace. So the court looked at the zero tolerance policy and then kind of zoomed in on the employee and her position to say, okay, it might be a dangerous site, but what do you do? If you use it the night before, does it pose a risk? And that is what the Labour Court evaluated, to say, you work in an office, it's not operating dangerous machinery. And furthermore, the court found that when you sit at your desk, and that's argument that was led to say, look, if it's health and safety issue, she's an office worker. She doesn't wear PPE at her desk. Your policy is overbroad. You are applying a zero tolerance for health and safety reasons to office work employees who don't require the same level of protection or safeguards as someone who would be driving your vehicles or working on a dangerous site. And again, the blood test alone does not show impairment. So if you ever look when they tested her, like we said, she showed no signs of impairment. And ultimately, the Labour Appeal Court concluded to say, in the circumstances, there has been a violation of the employee's dignity and privacy, and they awarded her 24 months compensation. Critically in this fact, I think this is the debatable point, is the court held that the matter could very well have been different for an employee who was found to be stoned. So if you actually show signs of intoxication or impairment at work, during office hours or on the premises, or if the employee who operates work with heavy and dangerous machinery. So what the court ultimately found is, look, this decision we've taken, it doesn't mean that this zero tolerance policy is not applicable, but we need to determine who does it apply to. If she was showing signs of intoxication at work, slurred speech, any other physical signs, or if this employee was actually working on a dangerous site. So it depends on the nature of the employee's job in order to successfully apply your zero tolerance policy. So the biggest takeaway here for me is that if you need to implement a policy for substance abuse, which I think in view of the recent findings, everyone should be reevaluating their policies and really looking at what they have. One, can you justify zero tolerance? Looking at your position of the employee, does it apply to everyone? Does it apply to only those doing dangerous work on a dangerous site? Does it apply to office workers? If you cannot justify it, you shouldn't be implementing it. And this is mainly your role of your Occupational Health and Safety Committee, and they play such a big role in this policy because they need to determine and do a risk assessment to say, can we justify it? If we can't justify zero tolerance, should we be implementing certain cutoff limits, like in the case of Marasi? And what should those limits be? So this is quite an important exercise that must be conducted in order for you to relook at your policy and make sure, like I said, it has to be tailor-made. It cannot be a one-size-fits-all. And then just lastly, a couple of days ago, I think it was late last week, Barloworld obviously did a leave to appeal to the Constitutional Court in the hopes that it would overturn this decision, and leave to appeal was dismissed on the basis that it did not have sufficient prospects of success. So as things currently stand, this is the law. And yeah, thank you very much.
Thank you, Tanya. That was excellent. There is so much law and there's so much noise about this, but you had that ability just to summarize it for us laymen extremely well. We're not going to do questions and answers now. We're going to do it later, but just to give you a perspective, my takeaway is that on the face of it, zero tolerance, not without certain conditions and parameters, but zero tolerance similar to the Marasi type context is acceptable where you have a high risk occupation, you've done a risk assessment, you've identified the inherent requirements of the job. There's not a lot of argument about that between all the cases that you've mentioned. You've got to do it right. You've got to do it sensitively. You've got to make sure you're not discriminating. So there are a whole lot of requirements. You can't just blindly say that you've got a zero tolerance policy. So even that needs to be tidied up in most substance abuse policies. But the extreme change is around the office workers. And for reasons that confused me, there was this sense that when you're in an office, you're in this perfect cotton wool-like world where there is no risk at all. And because you don't wear a PPE a reflective jacket or a hard hat when you're sitting at your desk. Therefore, there are no risks in your workplace. And for whatever reason, a BALA world either didn't put a lot of emphasis on the safety aspects and the inherent requirements of an office worker, or the court didn't place great weight on the safety aspects of an office worker. And for us consultants and corporate managers going forward, that's the biggest area that we need to focus on going forward. Have we done a risk assessment on office jobs? Is there an inherent requirement? How do we apply our policy of zero tolerance? Zero tolerance, we've now learned, can never be zero. If you breach it, you're fired. I would hope by now all understand that you have to consider the circumstances, you have to consider the merit. And if anybody was confused, the Enver matter has put that matter to rest. Zero tolerance has still got to be the investigation, and the chair of that inquiry still has to apply his or her mind and consider the circumstances. So that would be my quick summary through my lens, but I'm sure we'll dive into some more details towards the end. So again, well done and thank you. Connor, I believe now we're going to go to our quick poll. We just thought for everybody online, we would do a quick poll, having heard Tanya's very clear presentation. We just wondered what your sense is. I trust all of you have done a poll. If you haven't, it's a matter of moving your icon with your mouse or your pad or whatever you use. There's 5 options there, which my old eyes are battling to read. But given the legalization of cannabis, the private use of cannabis, and now in particular the Enver matter, do you think that this undermines the issue of workplace safety? Are you in full agreement? If you are, then you would tick the first block and say you're very much in agreement. If you're in partial agreement, but you don't think it's that serious and it can be relatively easily addressed, then you would tick yes, but not at quite the same level. Sorry, Connor, my reading, my liking terrible. The third option is not significantly at all, that the option is not significant. That would be the third option. The fourth option is not at all. And then the fifth option is you do not know. You're not sure. You will know. You'll know at the end of the webinar, but right now maybe you're not sure. So there's 5 options there. I think they all speak for themselves. If we could give you 1 minute to all just make your options, move your icon and click and submit. Let's give you 1 minute. That's all it will take. Tibor, you definitely don't have to vote. We know your view. Connor, you'll let me know when we're at a significant level.
Yeah. Okay.
So these are the results. Quite a liberal, objective bunch out there, I must say. So the overwhelming view is yes to some extent. So there isn't a great concern, and I suspect that because it's primarily focused on the office workers possibly, but everybody does have, the majority, 53% do have some concern. 18% not significant concern, and even 12% not at all, not worried. So there is concern, but it would seem that everybody is of the view that it is manageable. The caution would be, and I'm now repeating myself to some extent, it's how you deal with that, how you change your substance abuse policy, how you handle impairment, handling it sensitively and not unfairly discriminate. We've now got this discrimination aspect fully embedded in what was traditionally seen as a safety matter. We've now got to consider the right to privacy and issues such as discrimination. And that's possibly why the largest score, the predominant score, is 53%. Thanks, Connor. We're now moving on to our next speaker. As I briefly introduced him in the beginning, his name is Tibor Szana. Not all of you may know him because he is a deep safety expert. He's retired as the Chief Inspector of Occupational Health at the Department of Labor. So possibly some of the industrial relations and human resources people on the line have not really been exposed to Tibor. For those of us that have been involved in the health and safety space, we've been very exposed to Tibor. He's been very influential in our life as the Chief Inspector for a number of years. And there's very few people out there that can speak with quite the same level of practical knowledge around safety, and in particular, the implementation of the Health and Safety Act. And we heard from Tanya that with the Marasi matter and with the Enver matter, but the Enver matter was because they really didn't focus very much on that Occupational Health and Safety Act and regulations. But the Occupational Health and Safety Act and regulations are key factors that we would recommend employers need to be taking into account, which is the reason why we asked Tibor to join us today. Over to you, Tibor.
Thank you very much, Craig, and good morning to everyone. Is the presentation visible?
Yes.
Thank you. Okay, so the presentation that I'm going to do is split into basically two sections. If you look at some of the definitions, a piece of the legislation, and here I've just extracted some of the legislation, and then we'll look at the intoxication stroke impairment bit. And I think Tanya did a fantastic job in terms of looking at the legal aspects and so on, and pulling that all together. So it makes it so much easier with that background. So the relevant legislation, if you like, just a couple of the definitions. You'll also note that in this presentation, I don't dwell much on the aspects around the ergonomics regulations and how that impacts in relation to the subject. But let's quickly look at it. If you look at hazard, what is hazard? What does hazard mean? It's a source of or exposure to danger. How would that impact if you look at that? What is a source of or what is the exposure to danger when you are referring to this whole issue around DAGA? Danger then means anything which may cause injury or damage to persons or property. And then safe means free from any hazard. If you like, you refer to the top part there, free from hazard. Basically, you're free from an exposure to danger. And lastly, I want to bring your attention to what is the workplace? Where is this workplace? And here, very briefly then, it is any premises or place where a person performs work in the course of his or her employment. So obviously, if you're looking at the Occupational Health and Safety Act, you are not going to go anywhere unless you start with Section 8 of the Occupational Health and Safety Act, which then creates the environment within which the business is going to operate. Without this aspect, the business would not be allowed to operate. You have an employer, and that employer has a duty to ensure that certain things are in place as is required by the Occupational Health and Safety Act. So that is the 22 regulations, and that is the relevant regulations to your business, as well as the Occupational Health and Safety Act. So if you look at Section 8.1, Section 8.1 is very clear in terms of what the employer should be doing. The employer must provide, when they start up, they are providing everything that is required to create an environment that is safe and without risk to the health of his or her employees. But not only is it that at the outset of the business that they're going to set up something, but it is obviously important that throughout the business that the employer is ensuring that the business is safe to operate. And this is where the maintaining bit comes in, and this is where the businesses generally fall flat in terms of their day-to-day operations. And I'm generalizing. My experience is that most, if you're looking at compliance levels, and this is just before I left 2 years ago, compliance levels hovered between 50 and 60% compliance for your private sector, and I'm not going to refer to the state component in terms of compliance. Now, that level of compliance, obviously, you can say, what did it affect? And there were some critical aspects, such as having in place your health and safety committee, your health and safety reps, and everything that requires a business to operate. So just revisit that then. The employer shall provide and maintain, as far as is reasonably practicable, a working environment that is safe and without risk. Now, I'm not going to go into the definition of reasonably practicable. That will require time for a discussion on its own. However, be clear that the ecosystem for a business, that is everything that requires the business to operate optimally, is captured in Section sub 8.1 and sub 2. The following aspect then in sub 2, the employer's duties under subsection 1 shall include, and then it goes in to the detail, the provision and maintenance of systems of work. What is required by the employer in terms of his particular business or her business for it to continue to operate and ensure that health and safety is there for the workers. Remember now, if you were to take all the workers out of the workplace, does it mean that health and safety is not applicable? No. When you look at Section 24, there are other aspects that shows you that the relevance of having a health and safety system in place. But that's not what we're going to discuss today. So if you look at Section 8 then, Section 8 ties in nicely with part of the summary that Tanya did a moment ago when she spoke to the nature of the business and the steps implemented in the interest of health and safety, taking steps then under sub B to eliminate or mitigate any hazard or potential hazard. That is the responsibility of the employer. And we'll see in a moment how this affects the employee as well. Making arrangements for ensuring the safety and absence of risks to health. Again, you've heard it repeated several times. The whole issue around a risk assessment, the risk management component becomes quite crucial. So quite importantly, the employer is required to establish the hazards attached to any work. And as Craig was talking just a moment ago, this becomes very, very critical. The employer is then also required to establish the precautionary measures to be taken and provide means to apply it. So if you're going to have people in your workplace, what are you going to have to put in place to ensure that people are in a position to work in a healthy and safe manner? They must establish hazards. And in doing so, they must establish the precautionary measures to be taken. But not only that, the employer must also ensure that they provide the means to apply it. So in the broader sense of, as we talk ecosystem, you can see that the the whole health and safety model, if you like, is coming into fruition as we go down into Section 8. So further to this, the employer has opened the business. The employer is then required to provide information, instructions, training, and supervision as is necessary at the workplace. It's not just good enough for the employer to start up a business and say, I'm providing employment for workers, which is what I encountered at one construction site I did an inspection at many years ago. The construction work supervisor had X amount, in this case it was $1 million, probably 15, 20 years ago, for health and safety, and said he doesn't give two hoots about the workers and their safety and whatever. The money's there, the safety has been provided as far as he's concerned. Furthermore, he doesn't care about the workers. Obviously, that particular person should never have been employed, especially in a high-risk environment such as construction. No employee then is to do work unless precautionary measures prescribed have been taken. I think it's quite crucial that one sees how health and safety develops at the workplace, just working through Section 8. The employer must then also ensure that the requirements of the Act are complied with. The legislation, if you like, he or she must ensure that every aspect of it is complied with. And this is where the requirements of the Occupational Health and Safety Act, which introduced the Health and Safety Committee, is quite important, because the Health and Safety Committee is there to assist the employer in ensuring compliance with everything that the employer is required to do. I'm not going to go into the details of Section 16.2, where the employer or the CEO can assign certain duties to other persons in relation to the duties that the employer is required to do to assist him or her to ensure that the Health and Safety Act is complied with. Now, I think here, the enforcing such measures as necessary is something that is not entirely, looked at by the employer in relation to occupational health and safety. What are those measures that are necessary that the employer needs to enforce and make sure that it is so? So Section 8, this particular subsection H obviously becomes quite crucial for ensuring that health and safety is fully implemented at the workplace. Now, the following is under I, ensuring work is performed under supervision of a person trained to understand hazards and who have the authority to ensure that the measures taken by the employer are implemented, becomes quite crucial, and more so, as Craig touched on earlier, in relation to the workshop versus the office staff or the administration component of the business. However, it is something that cannot be overlooked when you are looking at the administrative component and say, again, as he has indicated, that as long as people work in the office, they are safe, and we know that that is not the case. There are serious accidents, including fatalities, that do take place in relation to office staff. Causing all employees then to be informed on the scope of the authority. Here they tie in both Section 13 as well as Section 37.2, Section 37, if you like, that by doing so, the employee is in fact clear on what it is that they are required to do. And we'll cover that a little bit in a section or two in a moment. So if we go on to Section 14, Section 14 becomes quite important because these deal with the employee's duties. Now, the employee normally thinks that there's nothing that ties them in or can tie them up when it comes to occupational health and safety, and the realization that they do in fact have an important role. Health and safety at the workplace is about a relationship between an employer and an employee. In this particular case, when this particular act came out, the OSHA 85 of 93, it was the fourth act that was brought out since 1918. And in this particular instance, what they sought to do under the new dispensation, which then came about, was to ensure that there is a relationship where the employer and the employees can sit together to resolve their own problems. So it is about self-regulation. And when we talk ecosystem, it's employers, employees, employee representatives, and it is also all other components that assists the employer to run the business, as I said earlier, optimally. So what is this about the employee? Every employee shall at work take care for the health and safety of him or herself. And if you're pitching up at work and you're intoxicated, what does that mean for yourself? And what does it mean for others around you? Now, the others here should be very important, because it doesn't only mean others being your colleagues, your work colleagues, but it could be the exposure of other people that are not employed by your organization. And we know, for example, the retail and wholesale sector, we know that in the government sector, people are constantly going in to the workplaces in order to do various things that need to be done. And remember that the state is not exempt from this legislation, the Occupational Health and Safety Act. Very importantly, the employee is required to cooperate with the employer or the person that's been assigned any duties by the employer. Why is that important? It means that when you are given a particular instruction, there's a requirement placed on you to ensure that you comply with that, failing which it could be a contravention. Under C, it says carry out any lawful order and obey the occupational health and safety rules and procedures. Under Section 8, we saw that there was a component that spoke to supervision, and that supervision does come up again. And in this particular instance, there is no excuse for an employee when they get given a lawful instruction in terms of the Act for them not to carry that out. And then lastly, quite importantly, you are working with other people, which means that when you become aware of an unsafe or unhealthy situation, there is a requirement placed on you to report that to your health and safety rep, or directly to your supervisor, or to the employer or the employer representative. Very, very important. We need to obviously ensure that our workplaces are healthy and safe for all of us at all times, so far as that is within our power. I've spoken early on about the duty to inform, and of course that's quite important. So while the employer has set up everything that is required, there are things that are happening constantly at the workplace, and the employer is required to ensure that the employee is in fact up to date with what is happening around them. It could be simply, for example, an occupational health and safety inspector from the Department of Employment and Labor visiting your workplace. And if they then serve a notice at the workplace, there's a duty on the employer, as an example, to make you aware of that notice that's been served and the reasoning why behind that. So if we go to the first part, then I need you to understand that when the employer is informing staff about, for example, hazards and the precautionary measures that need to be taken, he needs to ensure, or she needs to ensure, that the employee is fully conversant. Now, that conversant means that the employer has gone out of his or her way to ensure that there's full understanding with the requirements of the Occupational Health and Safety Act for that particular issue that the employer is informing the worker about. So this section 13, you don't hear about it spoken very often, but it is something that the employer needs to take quite seriously because it does appear in a couple of places in the Act. Now, early on, you heard Tanya speak about it. You heard Craig also speak about it, that the Health and Safety Committee is important. We go back to the early 90s at the commencement of our democracy. You'll know that around about 1996, the whole issue of workplace forums were put in place. I said to you also that the Health and Safety Act introduced the whole concept of this workplace forums, or the whole thing around self-regulating what is happening at every workplace insofar as health and safety is concerned. And in this particular instance, probably one of the more crucial things, something that an inspector has to check on, something that I made a point of checking, is to request the committee meetings for several meetings that have taken place over time in order to see how the committee is addressing things. And quite often, more often than not rather, you'll find that these health and safety committees are meeting for the sake of meeting and not to address more serious issues at the workplace. A very simple thing like incidents that are taking place at the workplace are not being addressed by the Health and Safety Committee, and therefore recommendations that they may make to the employer are in fact not being addressed. The Health and Safety Committee also shall perform other functions as may be prescribed, whatever those may be. Let's say there's an introduction. There have been cases now around DACA, for example, that have come up, and some serious court cases that have been published. You'd expect that the Health and Safety Committee takes this up, discusses it, and then makes recommendations to the employer, for example, on changes to policy, more meetings with staff to inform them about what the employer is thinking about this and doing about it, and how they will make implementation with regard to changes, how the risk assessments have been changed, and so on and so on and so on. So the other important thing then is that the Health and Safety Committee shall keep a record of recommendations made. All this you can find in Section 20 of the Act, of course. Section 37, very briefly, deals with contractors, the whole issue around mandatories, things that are done and not done. And without going into the detail here, I think that if you go over this particular aspect, which you should, and if you are an employer that has been, your business has been going on for some time, you need to have a look at this. And very briefly, I'd just like to draw your attention to, you have contractors coming into your workplace, contractors that are impacting directly on what happens within your workplace. Your people are exposed, and your people are also exposing the contractors. Now, if someone has, in fact, let's say they are intoxicated and someone dies as a result of them being at the workplace, you as an employer are aware of it and have done nothing about that employee, you could be held accountable as much as the contractor whose worker was exposed at your workplace in relation to this whole thing that we are discussing today. So have a look at this, go through the details, how it could impact you, and remember that contractors come onto your site are not necessarily the only ones that will face the music, but you as an employer who's allowed people to enter your workplace could also be held accountable jointly and severally, as I say, as well as anyone else that could be found contravening the legislation. So anyone entering your premises, then you have to ensure that they are complying with your policy in relation to, let's say, in this case, intoxication, and any other policies that you may have that could be impacted on. And then we get to the important one under the General Safety Regulations, intoxication 2A. of course, there's an important part there. The employer shall not permit any person who is or appears to be under the influence of intoxicating liquor or drugs to enter or remain at a workplace. No person at a workplace shall be under the influence or have in his or her possession or partake of or offer any other person intoxicating liquor or drugs. The employer shall, where a person is taking medicines, only allow such person to perform duties if the side effects of such medicine does not constitute a threat to the health and safety of any person. And if you look carefully at this subregulation 283, in relation to the stuff that Tanya's gone through, then you'll also notice that there is a correlation between what the outcomes were of those cases and what we have here. In terms of the other parts of the presentation, it looks at the impairment aspect and addressing impairment and so on, and you can go through that. When is a person intoxicated is covered here, the effects of that and how people, early on you heard Tanya talking about the time or the length of time a person can be intoxicated. The word she used was that the person smokes it or consumes it in some other way during the nighttime, not the next day, because there is a difference and you will be found to be intoxicated if you were to go to work the following day. And one of the other big things about this is the amount that you consume of this substance. I think that is quite key. And also the length of time that this has been consumed, during the course of your lifetime, which becomes quite problematic. It's not just a case of you're going to have some now and there's nothing that's going to impact on you over time. You also need to be aware then of regular users versus those that consume the substance occasionally. There is a huge difference, and some of those things I touch on. I'm not going to go into the detail of that. When you do address impairment, be aware that there are some guidelines that I included in the presentation that I'm not going to go through, but suffice to say that you need to change your mindset where you're just going out and people are being charged and subsequently they are being released from the post that they had. You are required to have a look at how you can assist them and be aware that long-term use will mean that you are going to have a problem down the line with regard to the person that has consumed dacha, if you like, for years and years, and you'll need to look at how you are going to address that. Lastly then, recognizing impairment is essential for maintaining a safe work environment, and also regular training for supervisors and so on. That is the general staff, I think will help to ensure that you have a healthy and safe workplace without repeating some of the other things that Craig has also raised a moment ago. I think all in all, the subject that we have covered here now will give you a fair idea of what is required. Thank you very much.
Thank you, Tibor, and well done. It's when we get messages like this with somebody your experience, it just carries a whole lot more weight. As I said with Tanya's, we will handle questions at the end, but just to possibly help the understanding and the absorbing the things that came across to me, Tibor, strongly, and I think in the Enova Barlow world matter, and possibly some of the others, the issue that and I'm possibly sounding like a stuck record here, is the implications of the Occupational Health and Safety Act. And you've made it clear that in terms of the employer obligations, the employee obligations, and then what the general safety regulations say, how an employer should be responding to intoxication, we have to do something. We can't now look at the end of a Barlow world matter and say, oh, well, okay, so everybody in the office, we can possibly have a zero tolerance in testing on our sites or in our factories or in our foundries or whatever it is. But when it comes to the office, there's nothing we can do. There is an obligation. There's a legal obligation, especially on your senior people, your CEO as the 16-1, and then any other executives that he appoints below them. But on the employer generally, there's an obligation to do something. It can't just be overlooked. We can't put our head in the sand. So that was the one big message that came through. The other thing that resonated with me, Tibor, is we underestimate what the power of the Health and Safety Committee should be. We've all fallen into this trap, and I don't want to point fingers anyway, but we all treat the health and safety as a statutory requirement. It's short and sweet. We don't want any really deep or difficult discussions, but possibly it's time for those health and safety committees to be used properly. And one of the areas that they could be helpful is to help to clarify how we should be handling cannabis intoxication in the workplace generally, and including in the office. And then the final observation is that you have now explained to us what this intoxication is all about, because most of us are laymen. We don't really understand cannabis intoxication, and you've explained what it is and what it does. And we know it's not just red eyes. We know that your behavior changes, your cognitive ability changes, how you think changes, how your motor skills operate change as a driver, or if you're an office worker, how you work a large industrial shredder, your motor skills, your cognitive ability, and the like may well be affected, even though you considered an office worker working a guillotine or paper guillotine or a shredder could be affected. So that was fantastic. Thank you very much, Tibor. I'm now handing over to our final speaker, and that's Doug Armstrong, who is a senior consultant at the HR and IR consultancy, having spent many years in human resources in the corporate world, but he's also led a number of businesses. He moved out of human resources and was in some very senior leadership positions as well. And he's going to try and bring it together to some extent and look at this through a practical lens, Doug, in terms of, so what do organizations do now? I've tried to touch on some basics, but you're going to look at that for us and summarize it.
Yeah, good. Craig, thank you very much. I just want to begin by touching very briefly on some of the practical aspects that I think some of us may or may not know about cannabis, and also some of the medical literature and what the doctors and the medical people are saying, although I'm not a doctor myself. And then the intention is to lead into and give some information on testing and some of the levels that we could be looking at in terms of cannabis when we implement in our own organizations, and the new developments that are happening in those areas. And then, as Craig says, to try and put a lot of the very important information that's been delivered already today into some kind of context, because I believe with this now not going to go any further in terms of an appeal, particularly on the Innova and Barlow World matter, that HR, I think, is going to have to lead this sort of foray of cannabis into the workplace, and have to rely very heavily, as we've heard from Tibor and Tanya, on what occupational health and safety has to say. So with no further ado, let's start looking at the question of cannabis medically. And what was surprising to me, I have to say, is that after hearing all the hype about cannabis now being legalized, etc., it is still very much a controlled substance. And there is now the Cannabis for Private Purpose Act, which is Act number 7 of 2024. And this is where you'll find a lot of the information about the do's and don'ts. So in other words, how much cannabis you can possess yourself. So in other words, have in your own possession, how much you can have as a family at home of dried cannabis, how many plants you can have per person, and the fact that cannabis is still not a tradable commodity. So some of these aspects, I think, are very important because they're obviously going to filter through to the workplace as well. And then there's the critical issue around what is medical cannabis. Medical cannabis, according to this act, is only obtainable on a prescription and with the completion of what's called a Section 21 application. So it is very much still regulated by the medical profession and as such a controlled substance. Now the difference in terms of what we have recreationally, and this goes to the two main types of cannabis, is the fact that there are those that we generally, I guess, smoke, which is the THC, which has the hallucinogenic quality, which gives you the trip and the high and all of that stuff. And then there's the medical cannabis, which some people refer to as CBD, which is then the cannabis that you find in the oil forms, which is more medicinal. And judging by what the medical literature says, some significant benefits from taking cannabis in this form in terms of pain relief. A lot of people say that it assists them to sleep, and cancer patients in a lot of areas swear by the non-THC or recreational cannabis has been very helpful for them in their fight against cancer. The difficulty, though, is that the one we're going to, I think, be up against most often in terms of disputes and dismissals is going to be the THC containing cannabis. And this substance is essentially very different to alcohol. Prolonged use of THC can cause a thing that is called cannabis brain, which does have an impairing effect on the brain. And obviously that will create issues around productivity and people's performance in the workplace. And not only in areas where there's machinery. Obviously, if you have an accountant working with numbers and they have too much of this in their system, obviously they can make mistakes, which can, I guess, be just as devastating for a business. The other thing about cannabis that's important is that it's traceable in the system for up to 6 months. Now, a lot of people believe that it's only 6 weeks, but from what I've read, the cannabis, instead of being secreted out of the body quite quickly like alcohol through the being processed in the liver and the kidneys, cannabis attaches itself to the fatty cells, and that means that it actually stays in the body for longer and can be active for longer. Which then brings me to the last point on this slide, and that is that medically, cannabis affects people differently. So the way individuals metabolize cannabis, the type of cannabis that they've ingested, obviously, whether it's high in THC or has no THC, the amount, and the amount of time that has passed since they smoked or ingested it and they report for duty can also be very, very significant. So there's a lot, I think, for us as HR practitioners to read about in terms of cannabis and be at a point where we can actually advise and then inform some of the next heading, which is the whole idea of testing. Now, cannabis, unlike the alcohol tests that we've now become very familiar with, and I think the courts generally accept, If you look at cases like the Samancor Chrome, that's the Western Chrome Mines case, and Willemse, I think that case very clearly says that breathalyzers for alcohol purposes, for allowing people onto sites, are very much accepted and part of our practice and part of what we use in terms of zero tolerance. The cannabis, though, is completely different, due mainly to the effects that we spoke about, and the fact that people taking cannabis, imbibing it, smoking it, don't actually know what it is that they're taking on board. And an example would be, if you go to a pub and you have a beer, you know that basically a beer is a 0.5% alcohol content, and you know that after having 3 or 4 beers, you kind of reach your limit. When you light up a joint, though, you may have no idea of what is in that joint, what the other constituents apart from cannabis are, and what effect that's going to have on you tomorrow and the next day. So this creates a massive conundrum for testing. And as we know, and as we've heard, the only real test for cannabis in the system is the blood test. Yes, you can pick it up by urine, you can pick it up by swabs in the mouth, but effectively, you need to go the route of blood testing to establish a proper level. And the codification of what results in intoxication and impairment is also very unclear. However, if we look at what is, I'm sorry, I'm getting this thing, what in terms of new developments is on the horizon, there is now a cannabis breathalyzer that's been tested, and I'm reliably informed that the purpose of this machine will be quite similar to the Alcotest breathalyzer. It's going to detect the presence of cannabis in the breath, give a reasonable reading of what level you have, and also give some indication of the length of time since the product was basically ingested. So I think that's a big step forward, and is going to be very useful in terms of the way we write policies and how we use tests going forward. The other important bit of information is that the National Road Traffic Bill has, in its draft, come up with 3 levels, or 3 categories rather, of cannabis, and the levels that they will allow, which will declare drivers to be intoxicated or under what will become a legal limit. And what they've done is they've used the American standards, which, from what I see in the literature, is pegged for non-professional drivers. So in other words, casual drivers like you and me, at 5 nanograms per milliliter of blood. So even though it varies between states in America, that seems to be the standard that they're applying to drivers. What they've then done is they've said that when it comes to professional drivers, the legal limit for intoxication in terms of cannabis will be set at 2.5 nanograms per milliliter of blood. So your professional driver will only be allowed half the amount in his bloodstream when compared to the non-professional driver. And then they go a step further and they say that for both those categories, if you have another controlled substance that is present in your body, whatever level you're allowed in terms of those regulations is going to be halved. And this is to do with the fact that, as we said earlier, cannabis stays in the body longer, and its effects can be more long-lasting. So if you are looking for somewhere to go in terms of deciding on levels for your codes and your zero tolerance policies at work, there is quite a lot in terms of overseas information that you can use. And clearly that is what happened in the Marazi case. when they set their limits to be able to justify disciplining people and sending people home in terms of zero tolerance, they did exactly that. They used the international standards. So essentially, what we get to then is HR, in my view, having to come up with some solutions and some actions that we need to take, and advice that we need to be able to give to our principals, to our operations, and our senior management, on the basis that I think from what you've heard here today, there's not really going to be a one-size-fits-all solution. But what we're certainly going to have to do is begin, and obviously these points are in no particular order, but start with risk assessments. The reason why I say risk assessments are so important, I think, is just following on from what Tibor and Tanya have said, that the first thing they do is they establish some sort of a baseline. They give you levels that you can then introduce into your policies. And they give you a way of looking at the inherent requirements of the job. You can actually go out and assess jobs in finance, in HR, clearly the plant jobs, but you can get an idea of risks in any environment, in your workplace and across your workplace. And of course, involving the Occupational Health and Safety Committee in these types of decisions and investigations, I think is absolutely critical. The next issue is looking at your policies and procedures. And here I think we've got to the point now where we understand that cannabis is different to alcohol. It plays a different role. It's been treated differently in terms of legislation. So I think we have to treat it differently in terms of how we approach it at work. So what I'm talking about is all our policies, from our drug and alcohol abuse policies, our policies about entertainment, and then, of course, our disciplinary codes, how we are going to deal with zero tolerance in our disciplinary codes, and indeed, how we investigate issues arising out of cannabis use. We've discussed the issue around testing, and I think what we're going to have to introduce as well in our businesses is some form of an objective test. So whereas in alcohol testing, we have the ALCO test, and we have the various physical signs, whether the person is slurring their speech, the bloodshot eyes. Impairment, as we know, is critical when we investigate cannabis, and we're going to have to come up with some standards and in fact educate the people doing those investigations into what cannabis impairment and the standards, etc., that we need to conform to look like. Generally speaking, we should train, I think, all our staff, and that is something that Tibor has already mentioned. We train staff on drug abuse, on alcohol, but particularly now I think we need to look at cannabis. And I would suggest we even need to go as far as making sure that people know what they're allowed to do at home and what they're not allowed to do at home. There is certainly part of the legislation that says you can't use cannabis in front of children. And if you do need to use it for the children in the medical sense, there's a whole procedure in terms of that. So understanding and training staff, the do's and don'ts of cannabis is another critical area. Then I've put up this question of voluntary disclosure. I've always been a fan of where people have medical conditions at work. They should disclose these to either the company nurse or somebody in authority, based on the fact that, as you heard from Tibor, the damage or the harm that they can do to themselves, or in fact, damage or harm that they can do to other people. And I'm thinking here of people that have conditions such as bipolar, even people with various forms of epilepsy, and now, of course, cannabis. I'm aware of the fact that we need to be mindful of what the Poppy Act says about confidentiality. But I think the time has come for us to start getting people to understand that if they have conditions at work and if they're taking certain medications for those conditions, their employer and the people around them, for obvious reasons, need to know about that in case they have an attack or, in fact, they need the medication. So that might be a bit controversial, but we're putting it in there anyway for a bit of discussion. Then there's the question of collective agreements. And I think when I mentioned this to Craig, he went, whoa, we're going to have lots of drama there. Maybe that's the case. But again, there are collective agreements that have agreement in terms of zero tolerance. And if that is going to change in the workplace and your negotiations are coming up, this may be a very good time to put cannabis and cannabis use in the workplace onto the table and get your workplace forum or your collective agreement with the union to stipulate the levels and agree what your code is going to say about cannabis and what your disciplinary process is going to say about cannabis. Clearly, that also then becomes, which is the next issue, something for your EAP programs. I remember that in the very early days when people didn't really understand addiction to alcohol, we were very rough on people who arrived at work under the influence. Even if somebody said they were an alcoholic, we were not really very sympathetic, and a lot of those people got dismissed. However, as time went by and we learned more about alcohol and alcoholism as a disease, we changed a lot of our approach to how we deal with staff. And that was all incorporated then into our employee assistance programs. And today, I think most companies are fairly liberal when it comes to people who declare that they are alcoholics. They get sent on programs and they get assisted. I think we're going to see in future that cannabis is going to go pretty much the same way. And as our understanding grows and that of staff develops more, we're going to get to a point where cannabis is central to our EAP programs. Then as a last note, I'm very aware of the fact that the Employment Equity Act is very, very specific in terms of what we are allowed to test for in the workplace. And bearing in mind that many of our letters of appointment fairly glibly just refer to the fact that an employer may from time to time require you to attend a medical, the results of which will be disclosed to management. And that's kind of where it stops. The implications of that, I think, going forward, and those of pre-employment medicals and what we are going to use them for now that we know about cannabis and the way cannabis testing is going to change, will, I think, become very important and something that we have to deal with in our pre-employment medicals and any medicals that we do prior to recruitment. And in fact, what we put in our recruitment applications when it comes to cannabis. Do we in future ask people to declare whether they use cannabis recreationally? I don't know. I put that out there, but I think it's something that we need to guard against, because disallowing somebody or disqualifying them on the basis of the fact that they now take cannabis recreationally, I think could lead to all kinds of issues when it comes to recruiting and onboarding people in future. So those, I think, in a nutshell, are where we as HR practitioners need to focus. And these are the areas that we need to upskill on so that we are able to advise management, line management, and give them the research that they would need then to put into practice when it comes to making sure that we conform to the Occupational Health and Safety Act and that our policies are in line now with what the new cannabis legislation requires. So that is really all that I have to add. And thank you very much.
Thanks, Doug. Thank you very much. I must say, as you've developed your presentation and you've shared it with me, it's been very informative. Some very interesting angles have come out. Just to help the audience, my takeaways off the top of my head, without doing your presentation any disservice, is the importance of the collaboration between HR and occupational health and safety practitioners. It's very important that substance abuse policies embroider in the safety implications and the risks. If you don't, you run the risk of an Enver type decision that just ignores the safety implications. The other point which we know, but people and I think some lobby groups have conveniently obfuscated the fact that it is still a controlled substance.
Yeah, absolutely.
You can't go and buy a whole packet full of joints to take home and smoke.
Yeah.
That's illegal. It doesn't happen like that. And just the what's in this stuff and the difference between medical cannabis, people smoke a joint and think it's medicinal, when in fact, what has it got in it? What is it doing to them?
Yeah.
So there's a lot of noise and misinformation about that, and you've helped us to understand that. Also, it's very exciting to understand where the testing is going, because that is a problem at the moment. For a large employer, the only reliable test at the moment is a blood test. That's a hassle. And it's expensive.
Consuming expensive.
So the fact that there could be something coming along that's going to help us is important, and the fact that they, at least by do you call it the traffic act?
Yes, that's coming in. That's a bill at the moment.
So the fact that we could have some standards, it doesn't mean that it's applicable for us. Because of course, what a lot of us have done in the corporate world is, even though there could be an allowable limit on the road, we've still adopted a zero tolerance, but it will just inform the debate about what is intoxication and what is acceptable for an operator of a overhead tower crane in a foundry compared to what's the acceptable level for an accountant and the mines and the
winch drivers.
So we will be becoming more informed and more sophisticated. And then I'm not going to repeat it because most of it I have touched on already, but just all of everything that needs to be done. But the general message is review your substance abuse policy and all related policies, including your disciplinary policy and recruitment. The recruitment is very controversial. Maybe Tanya could chip in, or Rod Harper if he's online. But the reality, my gut feel is that if it's not an inherent requirement of the job, you should not be testing for cannabis as pre-employment. You need to have a really good reason why you're testing for cannabis. And again, it goes back to, have you done a risk assessment? Is it an inherent requirement of the job? So before we move to general questions and answers, any comment on that, Tanya? Would you agree with me? What would be your take on pre-employment testing for cannabis?
Yeah, I completely agree with you. I think we need to also be wary of discrimination in that regard, unless, like you say, we can justify it by either the working environment or inherent requirements of the job. So yes, I agree. Okay,
good. Thank you. All right, well, let's throw it open. Connor, you've been monitoring, I think, the chat box. Is there anything in the chat box? Can people put up their hand, or is the chat box the way to go?
Q&A. Use the Q&A.
The Q&A facility. Yeah. So let's throw it open to the floor. And any of the panelists, should they wish to add or ask a question of one of their colleagues? Especially Tanya always loves a difficult question.
Not today, not yet.
Nothing coming through, Connor?
Nothing yet.
Good. Well, we're well on time, so well done to the panelists. Maybe me forcing you to have 5 dummy rounds worked because we are well on time. And if there are no questions, we are available. We will circulate a copy of the presentation. Tibor's contact details are on that presentation if you're looking for that sort of angle. Tanya's contact details if you're looking for legal advice regarding this or anything related. And of course, Doug and I, from a general HRIR point of view, if you're looking for some training, some assistance to redo policies, let us know. We can always call on Tanya and the full team at Cowan-Harper to help us. But we are, as I said right in the beginning, if I could sort of turn the compass all the way around, we are in new uncertain waters. We are going to be learning as we go, as the tests come out and the standards about what's permissible come up. But the reality is, and this is what I said at the beginning, there's a requirement to do something. You can't do nothing. Cannabis, to some extent, is legal, although it's a controlled substance. There are people at your workplace who are using it. This Enovum case, it's a serious decision. It's not going on appeal to the Labour Appeal Court. So we're going to be living with the Enovum Barlow World case for years and years to come. If you don't read anything else, read Tanya's part of the presentation and read that case, because it's got implications of how you deal with cannabis users and people who test positive. You cannot use your zero tolerance policy on office workers anymore. That's the simple, blunt point that I want to share with you. You need to do something. And their lessons, Tanya, not it's not just for office workers, but the need for dignity, for respect, for the correct process applies as much to the overhead tower crane worker in a foundry or a dragline operator on an open cast mine. There are lessons. It's not all just about accountants and HR desk jockeys. It's about people in high risk work as well. It's there are lessons there of how we handle this. But thanks to everybody. Thanks for all the effort. Thanks for joining us. I'm not sure yet what our next webinar is on, possibly, Doug, on whistleblowing and the importance of whistleblowing. The one after that's going to be about the latest BEE Commission report as we prepare for our annual reports and start preparing new employment equity plans. Mike Beaumont and I are going to be unpacking that data for you after the whistleblowing webinar. But please monitor Facebook, monitor LinkedIn, monitor our website, and you'll see webinars at, we think, a very, very reasonable price around about every 6 weeks. Thank you. Sorry, the question has popped in. Sorry, I'm never going to read that, Connor. If you could read it.
Given companies allow alcohol at company events, is there any expectation that companies relax their rules about cannabis during company parties or events?
Well, essentially, no, because cannabis has to be used in private. That's the one. So you're not going to be able to have cannabis on show when you have your end of year party. That's one of the very interesting things, that it's particularly in the Act, it's very, very particularly spelled out that it's only for private use at home, and not in front of children or minors or anybody like that.
Tanya, anything you would add?
Yeah, I think this was dealt with in the Barloworld case, and they said it's rational decision to allow alcohol at a year-end function once a year, because like we correctly said, it's distinguishable. Cannabis, you're not entitled to smoke it at work, but alcohol you can use in public places. So yeah, I completely agree with Doug.
The whole thing about cannabis is it's the implications of the private use and the employee coming to work intoxicated or stoned, whatever your preferred word is. It's very different to alcohol. But great question. Interesting question.
Good question, because I think it's part of this thing that everybody now believes that because it's been legalized, it's open season. It's not. There are all these little shops popping up all over the place, supposedly selling cannabis. Now, those can't be legal either. I mean, in terms of that act, I don't know. Tanya, again, we refer it to you, but I mean, my understanding is you can't trade the stuff yet.
I think a lot of those shops do it on the basis of prescribed medical cannabis, or that's at least what they showcase. But yes, legally, no.
What you get out the back door might be different, but out the front door, it's just CBD, it's oil or something like that.
Hopefully harmful or harmless, in this instance. But yeah, do you know what you're actually getting? That's the problem.
Yeah. Anything else there, Connor? Yeah?
Can employees refuse to have a blood test done? If so, how do we deal with such refusal as HR?
Yeah, but Tanya, I'm going to send it to you in a moment, and maybe Tibor's got a view. This has happened to us in many situations. It happens with the breathalyzer. It happens with the polygraph, and the company then needs to respond, taking the circumstances into account. Tanya, would be my view. So if you suspect that the individual, it looks like he's impaired, you've done sort of impaired assessment. If the individual refuses, well, then you will take your decision based on the evidence that you have at your disposal. If they wish to protect themselves and prove that they're not intoxicated, well, then they should take it. So you'll then take your decision based on the information that's at hand. Tanya?
Yeah, I completely agree. Obviously, if they refuse, there's a very specific and strong inference to be drawn from the refusal. But you'd have to look at circumstances surrounding the incident, visual signs of impairment and things like that. And also remember to have as many witnesses observe the behavior and the signs of possible intoxication, because that will most definitely be put in the witness box in the CCMA.
Tibor, it looked like you might want to add something. You were nodding your head.
No, I think I concur. I think it goes back to the presentation that Tanya did, where I think it was the Eneva case where the person was sent home and told to come back and retested, and they retested. But that is all obviously part of your requirements, your policy, so that it's clear that you will retest. And if they are again not clear in the next test, you stick to it, and from there you start to take your HR decisions as part of your HR policies, the direction you're going to take, and you're going to have to commit to that. But to allow someone to go in and there are clear signs, the employer will open him or herself up to be charged in terms of the Occupational Health and Safety Act, without a doubt. Thank you.
And the point is, Tibor, you made it indirectly, but just to put an HR labor law spin on it, you have a policy that says it's a requirement. You probably you should have it in your contract of employment. It's referred to in your disciplinary inquiry. So there's an obligation on people to be allowed testing. So they're also in breach of their contractual undertakings if they refuse, and they can be disciplined for that as well. So it could become what could be one charge for being intoxicated, could be two charges, Tanya, intoxicated and refusing to comply with their contract of employment and or related policies.
Yes.
Good. Okay. I think we're at 11. I think we should wrap it up. Thank you very much. It's been enjoyable. And hopefully you all join us for our next webinar. Thank you. And thanks to the panelists. Thank you very much, Tanya, Tibor, and Doug. Well done. I think the three of you did extremely well. Thank you.
Thanks, Craig.
All right.